So hi everyone, I think we can now start. Thank you for joining us today with Julien to discuss about proof of use in practice and try to make the topic a bit more exciting than you tend to use it, be it in-house or in practice. So today we will see how AI can serve the IP teams defend and renew their trademarks, both. And yes, that's quite innovative. For that, we are happy to have with us Julien Cicluna. I let you maybe introduce yourself, Julien.
Hi, Julian from UZ.IP. Created this startup and this solution 2 years ago. I'm also a French French and European trademark attorney. There you are. I've been in the business for some years. I'm happy to be with you this evening.
Thank you, Julien. And I'm Marie Farge. At Questel, I'm leading the client solution specialist team. So it's a team responsible for doing demos of our software, trainings, but also to come and meet you in conferences and in webinars. And I would say, above all, we are the bridge. We try to be the bridge between our clients, our sales team, and our development teams. So this means we are after Julien and his team for UZ.IP, for example, trying to convey the message of what our clients expect and trying to adapt the roadmap to make the tools really fit your needs. So what is great with this specific UZ.IP platform, as you can all see here, is that we have experts behind the scenes in the development. So yeah, I think with Julien, with your team, you built the tool that you would have wanted to use yourself. So that's
Yeah, I did this. We built the tool really when I was before I was in a larger firm, and we had these clients, and we were really seeing the difficulties the clients had in collecting proof of use, and then the difficulties we had in the firm of collecting, analyzing, and using these proof of use. So it's really the tool is oriented for attorneys, but it's also oriented for in-house. It's both dimensions.
Great, we'll see all that. So we plan to start with our agenda. We will start with where proof of use creates friction. So what are the difficulties, the issues that we tend to meet with regards to proof of use collection, be it for here, especially in litigation. And of course, time pressure, difficulty in finding documents or duplicated documents. We know this. Then we will switch also to the renewal cases with a focus on the US renewals, even if, of course, can be also replicated for other countries that require proof of use at renewal. So we will do a focus on that. And then we will try to finish on the how UZ.IP can help. It's not a full platform demonstration. We really try to have you understand what our goal was and what is expected to be done in this system with AI. So let's start with our issues first, solutions then. So where proof of use creates friction. Here we will go together with Julien on the kind of journey that is supposed to be a bit your journey. So we tend to ask our clients if they do have a monitoring and a defense strategy. And here, of course, we once again refer to monitoring usage. We're not speaking about trademark watch. And if yes, then our next question would be, have you faced proof of use requests? If no, yes. So if yes, was it easy to find the documents? And this is where the answer is most of the time no. So most of the time documents are scattered and or outdated. I don't know, Julien, if this is something you want to comment on from real life experience on your end.
I think the scattered notion is important here because we witness, even now that we're implementing the tools with some large clients, we really witness that the outside attorney, preferred counsel will have documents. The subsidiary will have documents in a country. A distributor might have documents. The in-house will be keeping some documents. So there's really this notion of things scattered around, and when data is scattered, you can't really search it. It's not reusable. It's not readily usable. So one of the benefits here of the tool is this consolidation of data in a single repository.
Thank you. So that, yes, you will see at the end how we think it can help. And then in the was it easy to find documents? Sometimes the answer is yes. Great. You can have a great organization, even if manually it's really difficult to categorize on many goods and services, or this is a long discussion. But if yes, okay. But in the case of a litigation, was the trademark maintained? Yes or no? Because that's not the end of the story. And if the answer is no, the trademark was not maintained, or at least maybe the scope needed to be reduced of the goods and services, it's often because the evidence wasn't clear. So this is also where we think that UZ.IP can help, because it helps spot where there are gaps in coverage in terms of years, in terms of goods and services, classes, etc. We have a few other slides. We will not spend 3 hours on the problems, but it's really important also to draw this initial picture. So remember, the first question was, do you have a monitoring defense strategy? And sometimes and often the answer is not really. And here, of course, there is also an issue. Here, potentially you're missing out on value. And I guess same, Julien, that you had experience from the, I regret not having put in place any system.
Yeah, well, there's the system, and then there's how you use it. As you said, I mean, you can have a very good system, but then when you're manually doing these things, you obviously reach quite rapidly limits. Because when you're talking of, I had cases in China, for instance, where we had 25,000 pages. Now, who remembers 25,000 pages? It's very difficult. So even if you have processes, the absence of digitalization, and here this is where AI really helps us a lot to go into the documents, read the documents, search the documents. And that, I believe, creates value when you are able to actually use the data. It's not just cold data you're storing in different places.
Storing and reusing. So we asked also, do you consider that you manage proof of use easily internally? So most of the time, it's a bit of a repeat, but the most common pitfalls, there are 3 of them, a bit more, but hard to find documents, not sure what to provide, too short deadlines, we did not really mention it, but that's really key in terms of litigation, and then it's the rush to try and find evidence that is missing. So that's why we really believe you need a streamlined process and a centralized and searchable platform. We have another small journey of potential blockers. Some of our clients tell us, yes, we do manage proof of use easily internally. We do believe this works. So let's dig a bit. So in this case, how do you handle your proof of use? So either there's the external counsel who is handling it. So here we are in the point of view of a corporate. Okay, in this case, do you have access to the documentation that they maintain? Is it in their hands? If the answer is no, this is often the case, you are missing out once again. You cannot reuse by yourself, at least. The other question is if the documents are they stored and organized internally? And if yes, how many people manage this? Because that's another pitfall. If it is one person only, and that happens more often than we can think, then of course there's a dependency risk here. If the person leaves, change roles, or even is off on an unexpected manner, then data is potentially lost. Several people, then there needs to be a consistent system to avoid confusion, duplication, etc., as we were saying. There are also the question on duplication. So is the same document stored in multiple places? This is in general what is done when people try to really handle it manually. Then you have no choice, no other choice than duplicating, unless you are using, of course, modern systems at ours. So if yes, of course, duplication, potential errors, and outdated data. The last question here is, so how do you locate a specific document? So it's often manually, and of course, it's time consuming. So we go back to the notion of time. It's not the only value of using a system, but it's one of the main values, is that you would be getting a lot of time in the analysis and of those famous documents. So this is where, yeah, I think we try to help on all those different angles. We can cite more, but they are maybe the most important. I don't know if Julien, if you want to add something.
Yes, well, I mean, AI is perfectly tailored for large amounts of documents. And what we implemented also is an analysis of those documents according to legal criterions. So it's not just an analysis, there is a bit of a legal analysis. And there are, in fact, when you look at the decisions, you see patterns, and the AI works with those patterns. So it's very easy, in fact. And the more documents you have, in fact, the more benefit you have.
And the goal, we will see it later, is that partially the documents are added manually because some things need to be loaded manually, but there's also some integration. So there's this notion also of integration that can make you gain some time and gather more evidence than you were doing before, also from scratch. So this is the time for our first poll. And here we were wondering with what parts of the process do you think you struggle the most? Of course, regarding proof of use collection.
Thank you. Very, very interesting. The main result is not knowing where proof of use is. Now that can be in two. That can be where is it stored, and that's of course using UZ.IP. You know where it is stored, and you have access to it. And as we'll explain perhaps at a later stage, the tool is very collaborative, very open. It enables the IP or the IP department in-house or the firm to open up to different, I would say, players, like it can be subsidiaries, it can be outside counsel, it can be marketing department, finance. So it really facilitates the collaborative collection of the tool, even sending automated reminders to the people. So of course, we can't change people. I mean, if they don't want to collaborate, they won't cooperate. I mean, that's we know in big, large corporations, and even us as attorneys, it's often a problem that, like, marketing don't want to respond. They don't really understand what we're asking. So well, that we won't change. But by facilitating the handling and the process, we believe that we will increase the responsiveness. Then linking documents to the portfolio. Well, that is done automatically by the tool. That means your portfolio is downloaded to the tool. Once you you feed it with documents, and those documents are analyzed and linked to your trademark, and not only to the trademark, but to the goods and services designated by your trademark. And the relevance of proof of use. Well, the tool will evaluate for each trademark the relevance from a territorial, temporal, product and service point of view, the relevance of the proof of use you have. That means you can actually go onto a trademark and monitor the proof of use you have at that date to evaluate if you have to file an opposition, send a cease and desist letter, or even renew.
Thank you, Julien, and very interesting. Yeah, thanks again for participating. It's always great to be able to also get your point of view on our webinars. We thought, okay, we have painted a picture of the most common pitfalls and issues, and let's dig into some real life cases. There's a big EU-IPO focus here, sorry for people all over the world, but as you can see, it's not only focused on European owners. So our first use case here is the famous, I think I can say, Big Mac case, where Big Mac here, McDonald's was challenged. Sorry, there's a small typo in the date here. At least you can see it's a human who wrote that, it's me. But in 2017, Supermax, an Irish chain, sought to expand in the EU, and they faced opposition from McDonald's for their trademark, Supermac. Well, okay, it's McDonald's, it's Big Mac. We can all say, I think it's a famous trademark. But the EU-IPO ruling was that McDonald's failed to provide the sufficient evidence for the genuine use for all the goods and services covered by the Big Mac trademark. So here, because of this Irish corporate who felt strong enough to attack McDonald's, McDonald's lost partially, of course, not completely, but lost part of it over the coverage of this McDonald's trademark in Europe, in the EU. So I think our conclusion here, it's quite obvious. So you see also it was quite long because it started in 2017, ended after appeal in 2024. So I think some time, efforts, and some expenses were put in this procedure. So our conclusion would be here that brand fame does not replace proof of use, and it would be a mistake to believe it does, especially in the EU. And generic marketing evidence is not enough, because this is all in all what McDonald's had in their hands, not enough invoices, etc. So really marketing material. Julien, I let you comment if you want to add something.
No, very quickly. I mean, this case has been commented a lot, but
Yeah.
I mean, it's just an illustration. I remember a few years ago, I had a case. I was attacked. One of my clients was attacked, and we requested proof of use, and I knew that the trademark was used. I could actually see the proof of use just in a shop near the firm. But they failed to accurately provide and structure this proof of use, and they lost. So it's not a question of being right or wrong here. It's a question of having the good file and the good documents.
And the famous 5-year period. So this is an extensive period, and this is why what we really advise is to set up a process to be prepared and not just wait for the last minute. Here, of course, a tool like UZ.IP can help, but you have still waited last minute. It will help, but the best is to put it in place just to avoid issues. So that was our first scenario. We have another one that I think is quite interesting. It shows also that the solution is never 100% a tool. It's also in the hands of who is using the system and how, etc. But here it was Ferrari on the trademarks Testarossa. I'm not fan enough of cars that I knew this car, I confess. So I learned it on building those scenarios. So here they were challenged by a third party, and the EU applied for revocation of the trademark, but Ferrari managed to prove that there still was use, even if it was on second-hand markets. But use was really active, and they could prove it. So here the result of the appeal was positive for Ferrari, and the General Court held that they did indeed use Testarossa in the context of certified of course, second-hand Ferrari vehicles and spare parts. So here our conclusion is that genuine use can exist without new sales, but if the mark is still playing a real commercial role. So yeah, another interesting angle.
Yeah, obviously a very interesting decision, and congrats to the attorney on this one.
Yes.
But it also shows the importance of having, I would say, legacy documents and keeping documents on a very long time, and being able to search and use those documents over a very large number of years. Now in Italy, they have this concept of historical trademarks, which obviously they are perhaps more aware on these things, but it's clearly here we have a company who has a database and is clearly maintaining a use database over a long period of time.
Absolutely. So ready to defend themselves on cases that are clearly not the simplest ones here. Another one, we have 4 in all that we wanted to share with you, is the Age by Hermes. So this was also at the EU IPO, third party filed a revocation in 2022. And it was on specific goods that was beyond the core leather products. And here it was judged that there was insufficient evidence. So it relied a bit like McDonald's, mainly on branding material, limited documentation. So lack of actual commercial exploitation on specific goods. So it's again, of course, a restricted loss of scope, but it is one. So owning a prestigious brand, we can conclude, doesn't exclude the non-product specific use evidence. And that's also what we insist on when we go to the US renewals, and extracting goods and services, not only classes, and analyzing the documents really in detail. And the last one that we have is Baccarat. So here it's also quite recent. We tried to find recent cases. So in August 23, the third party applied for the revocation of the Baccarat EU trademark, of course, not for other goods, but beyond the core Questel business. So it was notably on the textiles and clothing. And here, the evidence was also considered insufficient. So sporadic, commercially insignificant. It's a bit harsh, but that was the decision from the Board of Appeal. So here, the image that illustrates is coming also from a second-hand boutique or web shop, Vestiaire Collective. Seems in this case that there was not enough, and the second-hand documents were clearly not enough to help in this specific scenario.
Here,
So,
Marie, just
yeah.
if I may, it points out to one interesting thing here, because Baccarat, the core of Baccarat is Questel.
Yeah.
And they make very old, renowned, high-end Questel tableware and other materials. And so the other products, typically clothes in class 25, are, I would say, diversification around this core luxury. And it can also be, this shows it's also important to be able to monitor and keep proof of use for those diversified products around the core business, where normally the core business, we have access to good proof of use, and on the little sides, perhaps a bit less, because it's not as strategic than the core business. So, and obviously, the tool here helps, because as it collects everything and it analyzes everything, you could find quite easily, incidentally, documents which pertain to the diversified products and not the core business.
I think it's very interesting what you are saying, Julien, because we sometimes have some of our clients who tell us, I will not track all our trademarks. We will focus on the key brands. And our answer is, oh no, put just everything in UZ.IP, because the tool will analyze anything that you provide. So as you were saying, Julien, it can coincidentally find something you were not focusing on, but that can become useful in a case. And so that's also, you will see later, our advice, not only to track in UZ.IP the registered trademarks, but also the in-use trademarks, by the way. So really, that's part of it. We will see that later. Yeah, I think we are quite good on time for the moment. Not too slow, not too quick. I hope so. Our second part is on the renewals, and here we focus on US renewals. Once again, keep in mind, can be outside the US to unit proof of use in other countries, jurisdictions. In the US specificity that I guess most of you know, in 2020, they implemented the Trademark Modernization Act. And the goal of this act is what we will see is a trend of almost all PTOs worldwide, was clearly to clean the way. So clean the way for a clean and use-based register only. So based on this Modernization Act, I would say the first target was, of course, as you can see how they, and I think they can proudly boast on having removed in August, I think last year, 50,000 goods and services were cancelled from trademark registrations. They were targeting a lot, of course, the specimen farms, what we call specimen farms, fake websites, fakely advertising products, etc. But there's a full procedure to try and signal them also online at the US PTO. But that's not the only target. It's really clean path and yeah, give room to live businesses. We know the trademark world and trademark registries are packed. So there is really an effort to clean the registries. So that has a consequence, of course. It shows how strong the intent is to register and renew only trademarks that cover the exact and specific goods and services. And we know how strong it is in the US that are mentioned in the registration. Julien, you tell me if you intervene or I go to next slide.
Sorry, I think here the more rigorous approach of the USPTO in the specimen of use is also to integrate at the beginning a post-grant audit on the specimens, and that's the tool helps you, I would see, determine exactly what you have in stock when you file the renewal and what you produce. And so you can really tailor the specification of goods and services you maintain and fully anticipate in case of an audit.
Yeah. For filing, for new filings and renewals alike here. So there's one real life scenario that just showcases this strictness, I would say, of the US PTO, but not, of course, the only one. So here it's the old school case. It happened in 2-3 years ago, 3-4, time passes. The TTIP granted petitions to cancel 2 registrations for the mark old school. So here it was for clothing goods. And the reality behind this trademark was that the owners were not intending to use it, they were intending to sell it. And so they attempted to license or sell the mark. And their attempts, they could prove their attempts, but they did not manage. And intent to sell is not intent to use. So the real use in commerce is really what matters. Our last example that concerns here also a US case, it was Lens.com versus 1-800 contacts. So both work in and selling lens products. But Lens.com had also registered computer software. And they never sold a software. They were using websites to sell their products. They were not selling exactly a software. So this was found an illegitimate use in commerce of these specific goods. So software protection was cancelled, which, I mean, if you're really not using it, it's no problem, but maybe there's a loss of time and energy here in finding wrong goods and services from the start. So here it's a really same conclusion as before. Use must match the exact goods and services coverage. And in the US especially, we know we must refrain from overclaiming, which is a bit easier elsewhere. Doesn't mean you would not have difficulties defending yourself later. But in the US, it's just a loss of time. So that was our last example for the US. In the how it is typically managed here, we switch from the corporate point of view, how they tend to manage their US renewals. And we see it's really specimen focused. It's a point in time exercise. Even if you know it's going to renew, it still happens last minute, a few months before renewing or the months before. There's most of the time a minimal reuse because we have seen it's rare that data is really centralized in one place. So this leads to minimal reuse. And that's why we say it's kind of compliance driven. I must comply, I do it, and next time I will do it again, and next time I will do it again. So here the notion is that it's really treated as a filing requirement and not as it could and should be as a reusable asset. That's what we see. Yes, Julia?
The point here when we worked on this use case is that obviously we didn't have, the tool doesn't function in the same way when we're dealing with specimens of use, whether in the US or in other countries or territories where they are required. And then when you are dealing with a use case in Europe or even Turkey or Switzerland, here we go and fetch, the tool fetches automatically on a day-to-day basis. Each time you would refresh the search, it fetches 1 or 2 documents which clearly match over the last 6 months the goods and services in the specification. That means that the tool actually reads the documents, interprets this or reads those documents and says, okay, this is for class 3 soaps, and I link it to the trademark in class 3 for soaps. And it really goes point by point. It's very precise. So you really get a clear idea over time of what you have in stock. And again, the more you put documents, the more the tool will find documents, obviously. And the more you anticipate and save time.
And especially when we speak about web shop, for example, screenshotting web shop, which we can automate in UZ.IP, there is also this notion that most of the time there are several brands, several trademarks that can be found inside this document. This is why we insist on the reuse also. And here comes our second poll that is really related to what we just discussed. And the question is, do you internally struggle with proof of use for the renewals? And where do you struggle the most?
Yes, so I would say the poll, thanks again for your answers, but the poll a bit illustrates what I just said, is that you're 37% who said that you lack ability on proof of use for specific goods and services, and we try we address specifically that problem by linking precisely the documents or even a website or an e-shop directly linked to the products or services in the trademark registration. And I would say that if this is if the tool is used and a bit anticipated, if it's fed on a regular basis through, let's say, integrations on e-shops, marketing, and what I described earlier, this web of opening up and actually sending reminders to different counterparts in the company or outside. The question of the last minutes is also, we hope, handled or at least mitigated.
Yeah, mitigated, that's the word. We try to mitigate this.
No solution is absolutely perfect. I mean, it's
Great. Thank you, Julien, and thank you all for replying. We will have a third one at the end. And so our conclusion is on how we believe that UZ.IP can support evidence collection, organization, and reuse. In this, what we were saying a bit before, if we go back to the issues, even when internal management seems maybe easy, you may face some over-reliance on individuals, scattered duplicated data, inconsistent organization, and difficulty leveraging evidence across multiple legal or business contexts. So collaboration. Here, that's where we think UZ.IP is providing a centralized access, a smart search inside documents and trademarks, collaborative workflow, quick preparation of proof packages, because there's the full annex creation, it's all automated. We often, most of the time, Julien, we have eyes wide open when we show the annexes that are automatically created by the system. And last but not least, because it's also a consequence of organizing and categorizing the documents, that UZ.IP also allows to rethink old filings. Because if you can find what you are using and what you are not using, you will also find, as Julien was saying, potential use that you might be doing. And here it's really interesting, because the system will always be showing you for what class the specific document could have been used. And then it will show you what trademark is found in this document. So if you find a trademark, if you find, some classes, but not a trademark, it means maybe, of course, the answer is to be thought about by experts, but maybe you could have registered those classes, at least some goods in those classes. So that's also, that opens, I think, and gives a very smart insight on the reality of not only the portfolio, but of real use. So yes, aligning portfolios with real use. Yes, Julien?
There's aligning, I mean, the point here is that once you have structured data, and that we structure the data thanks to AI and the search criteria we have, you can, in fact, start using that data. You do data mining. And there you, in fact, get information, new information, which you didn't have before. Like typically, like a reverse audit of your portfolio. Okay, you know what you are using it for, but now it also tells you what you are using it for, but which is not registered.
Yeah.
Or one also very cool feature, depending on in which jurisdictions you are, is the possibility to monitor common law trademarks, first to use trademarks in any jurisdiction in the world. And he will just go in and scan the documents you have and say, oh, I found something in Aruba, or I found something in the US, or I found something in such a state. And And so that actually enables you to see, if I may use the expression, you see new things, which perhaps you were not seeing. We implemented this common law tracking for a large client, and it actually created in his portfolio 7,500 new trademarks, 250 trademarks in 30 jurisdictions, 7,500 trademarks throughout the world in the common law jurisdictions. And he is monitoring them, which in fact he could not do before.
Yeah. That's a great example of going further than just defending, but also creating value, not only defending. So here it's simple. Once again, we didn't plan to do a full demo. If you are interested, we'd like to do that on a customized manner. So we prefer to really meet with you all. You know where to find us. But to show you a little bit of screenshots of the platform, here it's a document page showing where you can check by trademark what is the overall potential coverage with regards to the documents you have. So here, as we said, for registered or in use trademarks, you can use the system. The system is really using AI to automatically analyze the documents. Here you see an example of document in French, but it could be in whatever language, because the notion is, of course, those are large language models behind the scene. And with large language models, whatever language is understood. So this capacity is also something we have not discussed of before, but that's really key. And to inform a little bit also of how technically it works, to really link territories to a document, it will first look into does the tool find a specific location, a specific address, country name? If yes, it will link the document to this specific territory. And if not, it will be based on the language. So a French document, for example, could be also used in French-speaking part of Africa. That's the theory. It means that then if there is a litigation case in one of those countries that speak this language, the document will be automatically retrieved by the system, could be used. It's always a could be used, because of course you have your hands in the system and you can edit, modify, and validate. We have a validation, a human validation capacity to make it just clear that it was not only analyzed by the AI, it is done, so you gain time, but you can review and validate. Yes, Julia, you wanted to add something?
Yes, I think this question of validation and control is very important, especially for us attorneys, where we do tend a bit to be dubious on things we don't control. And so the tool was really done in a way that you have full traceability of everything which is inputted, outputted, modified in the tool. You can really, there's full traceability of everything. Point one. Point two, there is a full control of the documents you upload to the tool. Yeah. That means nothing is randomly downloaded. Why? Because this was built by attorneys and we wanted to have something where at the end of the day, you can produce a document before the PTO, before a judge, or customs or whatever, so official administrations, and you can't afford to have a corrupted document or a wrong document, or imagine an infringement, a copy of an infringement, or even non-approved parallel imports, things like that. So it's really this notion that it's controls. You really keep a full control on what you put in and how it is used.
This is why, by the way, Julien, we are not crawling the web. When we integrate website, yep, we integrate the authorized, legally validated websites from the owners. So we make sure that we are not proposing to a PTO or a court an infringement. Yeah. So this is key. In fact, you do not want to use a system that would validate and automatize too much. That would be really bad. And for web shop, also something that I don't remember if we cited before, because that's not only for the US renewals, but it was requested from clients interested in using the system for US renewals. We added the web shop analysis that goes a bit deeper, and that if it recognizes that the website screenshot being added manually or automated is a web shop, then it will try and find if the product is available for sale. If yes, you will see this product ordering possibility. And we have really seen that in the US, examiners have been more demanding, and website screenshots with an affidavit might not be enough. You might have to prove it is really sold. So that's another notion. There's the case management, which is what we can say the conclusion of using this system is still mostly to be ready to defend oneself. So the case management here, you would say, okay, my this trademark is being attacked on those classes, those goods and services in this country, and this was the date we were notified. And here the system will automatically retrieve all the documents that might be used for this specific trademark, once again, for those classes, this territory, those dates. And it will give you what we call a confidence score. Maybe you don't see it too big here, but you will also get the slides afterwards. And the confidence score is really would be different from one country to the other, because Julia and your team, you have been really analyzing thousands of real cases, opposition litigation, to analyze not only the rules, but also the habits of the courts. If you want to speak a bit about that.
Yes, to date, we have integrated the criteria of analysis of extracting from 15,000 cases, plus, of course, office directives, examination directives, even legal literature. We have people working full-time on updating continuously and adding new countries. So it's really, we analyze here the documents in the context of the territory of the trademark, not just out of the blue. And we take that into account in the algorithm when we give a confidence index. For instance, in some countries, affidavits have a heavy weight in the judgment, while as in others they don't. Well, this we take into account.
So it's a smart analysis. It's just not simple automation. And of course, as we were saying before, generate the office's compliant evidence record. Here again, you will have, the tool will be compliant to the specific requirements of the offices. So the EU IPO, for example, has recently changed a bit, and they expect to have a specific table with a list of documents. This is done automatically by UZ.IP. So once you have yourself reviewed the documents and validated that they are okay for you, then the annex and the naming of documents, the listing of the documents is all automated in the system. So you can find back also. That's, I think on the system itself, that's it. We will use 5 more minutes to, at least, to speak a bit about some examples of collaboration. We do believe that the tool is really, it's clear, it's quite obvious what the tool is doing. So we rarely have real questions on what is this system and why would I use it. Our questions are often more on where am I using it, with whom, and what's our internal organization with regard to this new system, because we are quite proud to say this is an innovative solution. So the idea is, okay, you start using UZ.IP. Here we give an example from a corporate point of view, and law firms, of course, we also have specific examples we can share. So in our example, we have Marie, and Marie is an admin of, it's not me who created the name, the admin of the corporate company using UZ.IP solution. So we have Thomas, who is also working in the corporate. It can be Thomas, maybe marketing team, accounting department, communication, and diverse teams, of course. And we have Scott here, who is external and who could be a licensee, a distributor, a partner. And we have Miles, who is legal counsel working for Marie and Thomas here. So the logic would be that the owners of the solution will load, of course, with the help of our teams, will load trademarks and proof of use documents in the system. You might see that in purple, we have added the different roles that we have admin, manager, operator. I'm not entering all the details here, but it shows that you can really play on the rights to make sure not everybody sees everything, which is not what you want. And this is also why we keep the users totally unlimited in this platform, because we know that one of the biggest issues is collaboration. So we want to simplify it. So here in our example, Thomas is manager or operator if you want to restrict what he could see. Miles and Scott as external have access also, but only as operators, unless they should see everything. So on their end, they would only be loading proof of use. It could be directly only in a case when it's needed, only for one litigation, or it could be a country operator. And also, as we were saying before, there's a part that is automatic. It needs to be set up. It's case by case, depending on the client's needs. But we can integrate websites and also document management system, and we can even go further because when the tool is API compatible, you could connect it with also finance tool. You could connect it even with mailboxes. So the limit is more where you just want to put it rather than what can we do. The goal for us is rather to not change too much the internal workflows. If there are no workflows, okay, let's create them together. But if there are some and you are already storing in a specific SharePoint, for example, it's just an example, your documents, your proof of use documents, let us go and grab them. We will not ask you to change. So that's a scenario. There are many others, but it's the goal of that, of course, is that all trademarks, at least if possible, and a proof of use are in the system and automatically analyzed by AI. And our last point is Julien was saying before that the team is really keeping track of all the evolutions of the laws, but not only the laws, also the habits of the courts and PTOs. What we can clearly see is the massive trends all over the world to make cancellations easier and less expensive. It goes together, and to clean registries. So we have many examples that you will be able to read when you receive the slides. US, we spoke about the Modernization Act, and there's an expungement and re-examination process to clear unused goods and services. Mexico, they have made the declaration of use mandatory, so not yet with specimens, but that's mandatory, so it's recommended, of course. Canada, they try to increase use hygiene. This is exactly the correct wording. So now there is a proof of use requirement for remedies. So you need to prove use to obtain certain relief in Canada since last year. It's quite recent. Some other cases are making it, as we said, easier and less expensive to ask for cancellations. And most of the time, it's not the case in China, but in most jurisdictions, when a cancellation request is filed, it's the owner who has to prove use. So the burden is on the owner. So if you are the owner of the firm responsible for your client's portfolio, you are responsible for spending time and energy proving use. So in the United Arab Emirates, quite recently also, they introduced an administrative cancellation procedure before the PTO instead of going to a court. And that's the exact same thing that happened for the EU and in Turkey also. So in EU, there was a directive. It's quite old now, but we see that different countries started officially implementing those administrative procedures instead of going to a court for cancellation. So France in 20, Spain 23, Italy and Romania are the most recent ones in 24. Turkey, same in 24. This means there's much more cancellation requests. And on the United Kingdom side, it's quite different. Here it's that link to the Brexit. The cloned marks are not protected anymore by clones in the EU. So potentially also they will have to really make sure the UK use can be proven. And China, as I said, kind of a different angle, because it's also easier to ask for cancellation, but the company, the owner, whoever is asking for this cancellation must prove that the trademark is not in use, the third-party trademark. So the burden is on their end. In the end, one or the other, UZ.IP can help, because you can load material, be it yours or your clients, or the one from the third party. Yes, Julien?
No, just this thing of that you can also use it to monitor use of a third party in litigation,
Exactly.
and to in fact not monitor but to analyze the documents you receive, and the tool will immediately see if they're good, if they have the good dates, if they're in the good language. It's very fast, efficient.
I think this is our conclusion that getting clean proof to use and maintain or defend the trademarks is not really optional, at least as we can see in many jurisdictions, we can't say it's optional anymore. And our last point quickly is that UZ.IP is one of the solutions that we work on with UZ.IP team and that we implemented, but as part of Questel solutions, there is a lot of connections between all our systems. So all the blue arrows here are existing connections that we have with Equinox, our IPMS, Markify, our search and watch system, Brown Proposal, which is a pre-filing workflow system, Qthina, our AI assistant. And what we are doing is we are using, number one, the Markify data, because this is the trademark registry data. We are using it in all the systems. So it is already connected with UZ.IP. This is how you can declare, we call it declare in UZ.IP a trademark by typing its number and retrieving the information from Markify. Of course, if it is on a full-size portfolio, we require an export from the IPMS, which makes sense. But otherwise, it's quite nice to know this connection is already in the system. And the one we want to add is the connection between Equinox and UZ.IP. So the goal would be that, that inside UZ.IP, you can automatically make sure that you collect the trademark portfolio that is in your IPMS to make sure it's updated over time. Of course, this is for Equinox users. But that's really the goal. So it's part of the end-to-end Questel solutions. And yeah, I think that makes sense. And this is more and more requested, these connections. Julien, we did it. We were a bit long. Yes.
Yeah. No, just this idea that you have to think, especially when you're using AI tools, it's interesting to think ecosystem and not just tool by tool.
Absolutely. So building bridges where they make sense, because a unique tool for everything is not realistic. So it's the building bridges and pragmatically, not by automating simply and blindly, I would say. So this is our last poll. Sorry, I had totally forgotten we had a third one. Oh, sorry. Let me go back. Last poll, and then everybody's free to go. So we were wondering, we see there's a lot of different ways to try and store proof of use when it's done. So do you currently log proof of use in your IPMS, or rather in a document management system, or not really? We'll let you reply to that. And what I can say maybe to finish on this point, when our clients are logging proof of use in their IPMS, we always have the same question. That is more a consulting question, which is, where do I put my proof of use documents? And our answer is always the same. Is before you have a tool like UZ.IP, where to put it? Because the reality is sometimes this document can serve for this trademark, but it could also serve for this other. And so do you duplicate? That's really a tricky question on the logging that in the IPMS. So we tend to advise maybe do a family folder, but it's tricky. So I think the easiest solution is in UZ.IP rather than in the IPMS.
Well, yes, we have 57% tell us, and thank you, that it's 60% tell us that it's not centralized.
Yeah.
And so there, what I would say is that if it's not centralized, that means it's not searchable. That means it's very difficultly reusable. And so that's where our tool comes in play and helps you, I would say, optimize this. And as Marie said, also in the IPMS, yes, link to the trademark, but then that means you have to link each document to each trademark on the document manually. It's a hassle. And here we do that completely automatically.
Thanks, Lisa. Thank you again. We've been quite long, so it's a bit difficult to answer all questions. I'm going to check a bit the questions and maybe reply to one or two of them. But for sure, we will reply afterwards in a written way to all of you who have asked us questions. So I see one of the questions is what is the model that we are using inside, and do we use only one? And what is the model we are using in UZ.IP? Maybe that's a question I leave to you, Julien.
Yeah. For the moment, we function exclusively, the whole tool functions under Microsoft Azure on a European contract, and our servers are in the Netherlands. And the tool AI, we use OpenAI through Microsoft Azure. That means on a specific contract, it's not ChatGPT, which is the app, it's really OpenAI as an engine. Yeah. And also I want to insist on the fact that our tool is an untrained AI. That means we use prompts. We don't train on the data used. We teach the tool to look for trademarks and for goods and services and dates in advance. He doesn't need training on your data. The data is cold. That means once the document is read, analyzed, we don't use it anymore. We just use the tags from that document to help you search the database.
I think it's key what you said, Julien, and it answered the second question. That was on do you train, does the tool train on what we do? And there is, that's a question that comes not only for UZ.IP, but for all the tools that we have at Questel that use AI systems, LLMs. And the reality is, if we were training, it would mean that your data is used by others. And that's exactly what we do not want to do for security and privacy reasons. And the other thing, it would mean that we are also fine-tuning the model, modifying it, meaning we would then be trapped into using it. And what is really the goal is rather to be model agnostic. So if ever another model becomes better over time, and this is, we know it moves very quickly in those LLMs environments, then you are free to change and adapt. You are not stuck. And even I know for China, for example, there's the goal of using another system that would be authorized. So you see that if we want to keep our autonomy, and us means also you users of the system, we have to be model agnostic. Yeah. I think that can be our conclusion. 1 hour, Julien.
I'm fine.
Yes. I hope this was useful and clear. And of course, we are ready to show more of the system to whoever is interested.
Thanks a lot for your time.
Yeah.
Thanks, Marie.
See you soon.
Bye.